America is home to 33 million small businesses, the beating heart of communities across the country.
And proof that the American dream is still alive.
This is a show about those dreamers and doers and the communities they serve.
Their real life stories.
Their struggles and successes.
Their grit, determination, and passion.
And the people who fight
to keep their American dream alive.
I'm Alfredo Ortiz.
I'm Elaine Parker.
And it's time for another episode of Main Street Matters,
America's small business megaphone.
Hi, and welcome to another episode of Main Street Matters, America's small business megaphone. I'm Elaine Parker, the president of the Job Creators Network Foundation.
And I'm Jordan Bruno, vice president of Job Creators Network.
Please subscribe to the show at salempodcastnetwork.com or wherever you get your podcast from. Today, we're excited that we are joined by Erin Wilcox. Erin is an attorney at the Pacific Legal Foundation, where she litigates to enforce the 14th Amendment's guarantee of equal protection under the law. Erin, welcome to Main Street Matters, America's small business megaphone.
Thank you guys so much for having me.
Absolutely. Well, we've had several of your colleagues on to talk about other issues. I love what you guys do at Pacific Legal Foundation, but tell us about PLF. What do you guys do there? What's your mission? And then tell us specifically what you're working on.
Sure. So Pacific Legal Foundation is a public interest law firm. We are a nonprofit. We represent people free of charge. And we help people whose rights are being kind of trampled on by the government. It could be the federal government all the way down to their local government. And we really work to defend people's property rights, their right to have, the government follow the rules, and their right to be treated equally and to have an opportunity to earn a living free from government interference. And so I work in that last area. I work in our equality and opportunity practice, because we really believe that when people are treated equally, when you're treated the same, no matter what your race is, no matter what your sex is, that's when you have the best opportunity to thrive, to grow a business, and to really, kind of live your American dream.
I love hearing that. So what are some of your, what are some of the issues that you're working on now?
So one big issue that we've really started focusing in on in these last couple of years is public contracting. And I don't know if this is something that you guys are real familiar with, but everyone from the federal government right down to like your local community college has to hire people to work for it, or to buy things from paper clips to building a new building. And they have to bid that out to businesses. And the only thing that should matter in who gets those public contracts is who can do the best job at the lowest price. But unfortunately, a lot of our governments have programs that are basically giving racial preferences to companies. So some portion of almost every contract that goes out has to be set aside for what's usually called a minority or woman-owned business. And at PLF, we believe that violates your right to equal protection. The government can't hand out benefits like public contracts based on the color of the skin of the person that owns a company. So that's a real widespread problem in this country. And it's something that we've been really lucky to be joining forces with some great clients and kind of fight back against that.
Interesting.
Wow. So, Erin, tell us about your case in Texas right now.
Right. So this is one of those public contracting cases. And we represent a company called Aerospace Solutions, and they are a public staffing company. So anytime anyone in the transportation industry or increasingly government needs to hire in some extra folks who have expertise in a certain area, a lot of times Aerospace Solutions can find those people for them, and they can place them for a long time. They can place them for temporary roles. But as they've moved to Texas, they've run up against this problem. And Texas has got a program that's been in place since the early 90s. It's called the Historically Underutilized Business Program, or HUB. And what HUB does is it takes a portion of every public contract the state gives out and makes you subcontract that to a minority-owned business. And for a group like Aerospace Solutions, the category they're in, that's 26% of a contract. So over a quarter of a contract that they could do themselves, they've got to give away to one of their competitors who's owned by a minority. And that's just really not sitting well with our clients. They really can't be competitive when they have to give away a quarter of their contract to somebody else. So they've come to Pacific Legal Foundation. We, are very much on the same page, and they've agreed to stand up and challenge this with the Texas government.
Oh, wow, that sounds great. Can you give our listeners an overview of the argument that you're planning to use or you have already filed?
Sure. So we filed this case last week. It's brand new, very fresh. But the argument we're making is a plain and simple equal protection 14th Amendment argument. It says that when the state of Texas is giving out benefits, so in this case, the opportunity to work with the state of Texas, it can't use race as a factor in deciding who gets to do that. I think that's something most of us can easily understand is, I want to be judged if I'm a business on how good my bid is, how good are my services, how good is my price. And, I live in Texas. As a taxpayer, I want my state dollars to be going towards hiring people who are the best and who can do the best job at the best price. And the hub program gets right in the middle of that. And it really just is, it can be abused. It's a waste of taxpayer funding, and it's not necessary. So that's pretty much our straightforward 14th Amendment argument, is that programs like this, they're unconstitutional and they need to be struck down completely.
I'm just sort of taking the other side of it. 25% of a contract, if I own a business, I have to give to a minority-owned business. How does getting 25% of the contract help that minority-owned business? It's not that much for them either. I'm giving away part of my revenue, but they're not getting that much. So does it really help? Are you kind of spreading the contract so thin? Who's actually getting helped here?
It can really depend on the size of the contract, for sure. If you're talking about a multi-million-dollar contract, that could be a fair chunk of change for a smaller business. But, one of the worst things about this program is just that it stereotypes minority and women-owned businesses. It's saying, oh, you're owned by a woman, you can't possibly compete with everybody else, so we're going to give you, a special handout. Or, oh, you're a Hispanic-owned business, you can't play on the same playing field with everybody else, so we're going to treat you differently. And it's ingraining that message. I mean, this program's been going on since the early 90s. So it's just reiterating and reinforcing that message every year that, minority-owned businesses can't compete, which is, of course, completely fake and false. Of course they can. And there are ways where if Texas wants to help small businesses, it absolutely should. Rising tide will lift all boats. But what you can't do is pick and choose based on skin color or sex who gets special treatment and who doesn't.
I can remember one of my first jobs out of college was with a staffing company, and they were brother-sister owned. It was a franchise owned by a brother and sister, and the sister owned 50% of the 51% of the company, so that they could apply for all kinds of government contracts as a woman-owned business. I mean, they knew that was gave them the upper hand at getting government contracts for staffing. And things like that. So it's been going on a long time. I mean, you definitely would have your hands full, I would think, within our government to root out these types of, really discriminatory practices happening. Are you looking at, sort of what's your scope of how far you will take this in other departments of the government?
That's a really great question because, just in Texas, just this state program applies to, I think there's over 300 state agencies in Texas, and you think of the universities and the community colleges and everybody in that. This is a massive scope. So a win in striking down the hub program will have a huge effect in Texas. And, we're prepared to take this case like we do with all of our cases at PLF all the way to the Supreme Court if we have to. But even more than that, these kinds of race preference set-aside programs in public contracting, they're all over the country. They're in the federal government. New York State has a 30% set-aside for every contract that goes out in New York State. So, and that's not, even counting the cities and the counties and everybody else that that could use hub certification in Texas for their own programs. So it's really just got such a far-ranging impact, and it's really why we feel it's so important to challenge this hub program in Texas at that level, because it's going to make, I think, life better for a lot of people if we can make it so that businesses get to compete on a fair playing field.
Mm-hmm.
Erin, are there similarities between the argument that was used to strike down affirmative action policies in university admissions? Would that factor into your argument at all in a similar way?
It absolutely does. And we really think that the reasoning the Supreme Court came up with in the affirmative action case applies directly to these public contracting cases, because, race-based programs aren't new, and they're everywhere. They're not just in higher education. And, one of the really important things that the Supreme Court said in that opinion is it defined kind of what the acceptable justifications are for having a program that treats people differently based on their race. And the court made the really strong point that this is such an inherently bad thing that there are only two reasons that you can do this, and the bar is really, really high. And those two reasons were either you're protecting people's safety in a prison riot, doesn't apply here, or that that you were trying to fix a concrete instance of a past discrimination. And that's just such a hard bar to meet. And that doesn't just apply in higher education. That applies in public contracting. The state of Texas says that it's trying to remedy past inequities and by using this hub program. But that's not good enough. That's not good enough to treat people differently based on their skin color. You've got to identify a specific time that you hurt someone and remedy that. And that just, nobody can do that. And so I think that was such an important thing the Supreme Court laid out as that test for us last summer.
Right. So do you think that, this is kind of getting to Elaine's point in her previous question, do you think we get to a point, this is obviously a very blue sky scenario, but if you could win a case like this, could we have a precedent that would make race-based considerations fall nationwide or at least statewide?
Definitely statewide. If we could win this case, I think it would certainly impact statewide. And, because this program, reaches into other county programs in the state, it would certainly impact that. But I would definitely expect other states to pay attention. If Texas is such a big economy, it's such a big program, that I would expect a win here to cause other states to reconsider what they're doing. And that would be such a great outcome for everybody.
Tell me, does the program really undermine the idea of leveling the playing field for all businesses, regardless of ownership demographics?
It really does, because what it's doing is it's putting a thumb on the scale for some businesses. If you're minority or women-owned, if you can qualify for this hub program, then you get a leg up. You get special consideration. People have to subcontract out to you. But equally, if you are qualified as a hub already, you don't have to contract out to anybody. So if you win a contract with the state, you can keep all the work for yourself. Whereas a non-hub business has to give away over a quarter of its contract to you. So there's no way there's no universe in which that's a level playing field. And that's, I think, one of the main problems that certainly our client sees with this program, but that really puts non-hub owned businesses at a disadvantage.
And you're in state court. What is sort of the venue? How is that? Is it a more conservative venue? Like, what are you sort of staring at there? I know it's hard to make predictions based on that, but I used to work with a lot of lawyers in corporate America, and I know how they'll look at what the venue is. If they were really down on a certain venue, it was going to be a bad day.
Oh, absolutely. So we are actually in federal court, but in Austin. And unfortunately, we were just assigned to judge number 2. So I don't actually know who that is yet. So hard to judge, but we're in the Western District of Texas, which sits in Austin, or our particular area sits in Austin. And it could be a mix. It really could be. But in general, Texas has good judges. The Fifth Circuit is certainly, I think, promising for an idea like this. So it's always luck of the draw, unless you're filing in that district in Amarillo where you get the one judge, but we didn't do that. But
Amarillo, is that the Rocket Docket by any chance?
that's the Eastern District of Virginia.
Okay.
But no, Amarillo, there's just one judge up there. So if you file there, you're getting him.
Gotcha.
So, lawyers like certainty. But no, I think as long as you get a judge that is going to give it his best and pay attention to the case, if we do our job right, we'll do the best job we can for our clients.
Erin, tell us about some of the other cases you've worked on in the education space. We work a lot on education, mainly education freedom. What you're doing, sounds like protecting magnet programs, maybe a little different, but maybe you could just talk about those cases and the outcomes from them.
Yeah, I don't know if you guys are familiar with some of these magnet school proxy discrimination cases that Pacific Legal Foundation has been bringing, but this is a really exciting area too. We have a case pending at the Supreme Court right now against the Boston Schools Committee. It's brought by our clients, the Boston Parent Coalition. And there's some really historic, amazing magnet schools, Boston Latin, and a few others that are like Boston exam schools. And a few years ago, kind of in the wave of all this George Floyd backlash that happened in 2020, the school committee in Boston decided to change the way that students were admitted to these exam schools. And mostly their point was there are too many Asian American kids getting into these schools. And so they wanted to racially balance their schools. As we know, you can't restrict access to a public school based on a student's race. And so the school committee knew that too. So what it did was it used a proxy for race on its applications instead of having kids check a box. And it used zip code. It used zip code instead. And it was really able to kind of manipulate how many Asian American kids qualified for its exam schools just by using zip codes. And so Pacific Legal Foundation brought a challenge. It followed on to another case that got up for consideration to the Supreme Court out of Northern Virginia, the Thomas Jefferson High School case, where the schools had done the same thing. In both instances, you have just horrible evidence of intent to discriminate against Asian American kids. In the Boston case, the school board president got caught on a hot mic making derogatory comments about Asian American parents' last names who'd come to speak at a school board meeting. And then other people were laughing about it. I mean, just awful stuff. And so our argument at Pacific Legal Foundation is that even if you're not using race to outright discriminate against people, you can't use a proxy to do the same thing. It's illegal to do it outright. It's illegal to do it with a proxy. And so the Boston case is up before the Supreme Court right now, hoping that they'll take the case. The Thomas Jefferson case in Virginia was unfortunately not taken up by the Supreme Court, but we have a similar case in New York, and we'll keep bringing these cases to the court until they accept it, because we just think racial discrimination has no place in these magnet schools whatsoever.
Right. Yeah, I lived in Northern Virginia for several years, and I followed that controversy pretty closely in the wake of George Floyd, as you mentioned. But it seems to have died out a little bit. I mean, I haven't heard the headlines over the last couple of years. Could you just update us? So what was the resolution? Have they successfully changed the admissions to this equity, and the court, the challenges by groups like yours have not been successful, or?
Yes. So in the Northern Virginia case, unfortunately, the Supreme Court didn't take the case, and so it ended there. But the result was the school was able to change its admissions policy. Thomas Jefferson used to be the number one ranked STEM public high school in the country, or number one ranked high school overall in the country. I believe it's dropped to number 14 this year. It's just, and what I hear from the parents there, that it has just gone downhill. It's losing great teachers, it's losing great students, it's losing programs. Because when you don't admit students based on merit and you admit students controlling for things like race, that doesn't always, produce the same school that you would have had. And the sad reality is TJ is not the school it used to be. And, we're hoping to prevent that outcome in Boston.
How do you see the new administration coming in impacting some of the cases that you're working on that are challenging these race-based cases?
Well, we're certainly going to hope for a better outcome than with the last administration. But, it's always hard to know. But we do certainly hope that the new education department will take, more of a hard look at what these schools are doing. And, education is largely a state issue, at least K through 12 is. But we can, hope for some top-down leadership and hope for some just common sense, really. It should be obvious to these school boards that you can't change your policy to try to have fewer kids of one race and more kids of another race. And so I think some stronger guidance, certainly from the incoming administration, would be really welcome for whatever effect it could have.
Well, they've talked about getting rid of the Department of Education. Would that change things dramatically then?
Again, not because I think states have so much control over K through 12 education, at least. Who knows? But it'll be interesting to think of a world without a Department of Education. We'll certainly see what happens.
Well, keep us posted on that. Where can people go to find out about your organization, how they can support your efforts, and other things that you're working on?
Pacific Legal Foundation's website is a great place. It's pacificlegal.org. You can read about our cases, you can submit questions, and follow all the stuff that we're doing.
Well, great. Well, Erin, thanks so much for taking the time to join us on Main Street Matters, America's Small Business Megaphone. And thank you all for taking the time to tune in and listen. Main Street Matters is part of the Salem Podcast Network. New episodes debut every Wednesday and Friday. You can subscribe to the show at salempodcastnetwork.com or wherever you get your podcasts from, and we will be back soon with another episode. Bye for now.